First case to come before the court is in re DR. Appellant has waived. Mr. Ackerwall, you will have your full 15 minutes should you wish to take it. You are already at the podium and you've done this enough to know to keep your voice up because this is being recorded on YouTube. Whenever you're ready, you can proceed.
Thank you, Your Honor. May it please the court. Attorney Neil Ackerwall for the child DR. Of course, I will not be speaking the child's name. Your Honor, actually this appeal, the one I'm arguing right after, are virtually identical cases. And I've never done that before, I get two back-to-back cases on the very same issue, but it's a very simple issue before this court. Did the trial court, the juvenile court in this case, properly grant the party, in this case the father, a Rule 60B motion of relief from judgment? Now, what happened in this case is mother, father, and I'm the guardian ad litem for this child. There was a mediation, after there was a finding of abuse, dependency, neglect, the case is proceeding at juvenile court. Mom and dad, they were not really in a position to take custody, or at least that was what everyone believed. We all suggested, let's try mediation, let's see if we can reach an agreement among all the parties. The parties did reach an agreement at mediation, where the great-grandmother would take legal custody of this child. So we had a hearing before the magistrate on the mediated agreement to see if parties were still in agreement, you know, what we had agreed, because if they didn't, then we'd have a trial for legal custody at that date. Mom, through her counsel, stipulated, said, yes, my client's fine with the mediated agreement, we're fine with giving legal custody to the great-grandmother. Father wasn't there, but his attorney showed up at this hearing before the magistrate and said, I just spoke to my client is fine with the mediated agreement, I can't believe he wouldn't agree to it, he understands all his rights, so I, on behalf of father, am saying we're fine with this mediated agreement, we want the court to adopt it. So the magistrate heard from all the parties, said yes, that's fine, I'll award the great-grandmother legal custody, and that was the end of the matter. 2 weeks to the day of the magistrate's decision, father's attorney then files an objection, as she labeled it, saying, well, when I said that I was fine, that my client agreed to custody, and I spoke with him and he was in agreement with that, that was all incorrect. And when I said that, I was wrong when I said that, I shouldn't have said that. So therefore, Judge, we'd like you to grant our objections and set the matter for trial. CSB filed an opposition saying, no, you were there, you stipulated, everybody was in agreement, it was his day. If he wanted to contest custody, he could have showed up on that day to contest custody. He chose not to, so, you know, too bad for him. Judge said in this case, well, it was invited error because he didn't inform his attorney of what the mistake was, you know, that he wasn't in agreement with custody. However, and this is on top of page 5, however, there was limited prejudice, and therefore I'm going to construe the objection as a 60B motion, even though no party asked for it. So I, on behalf of the guardian, have filed an appeal to this court. Now, this court, and I cited multiple cases that says in order to grant a 60B motion, first of all, you have to ask for a 60B. You have to say, I want relief from judgment. That wasn't done in this case. You have to say, what is the ground? Is it under B1, B2, B3? Under what ground are you asking for a 60B? That wasn't done in this case. You have to list the meritorious defense that you want the judge to consider as part of the granted relief under 60B. That wasn't done in this case. You have to submit an affidavit or other evidence to support your 60B, not just your motion, to support the operative facts for a 60B. That wasn't done in this case. So basically, the judge has said, based upon father's counsel's representation that she misspoke, and that she was wrong when she said her client, I'm going to just grant the 60B, and therefore he's going to have his day for a trial. And I'm arguing that's wrong on multiple fronts. You can't do that. There's no basis. First of all, he's not even asking for a 60B. So on what basis can the court grant it?
So he had filed objections.
I'm sorry, what?
I'm sorry for interrupting you in this sense, I apologize. He had filed objections.
Yes, and when you read the objections, the purpose of an objection is to say where you believe the magistrate committed, reversible error. And the judge says, in reviewing, well, I'm going to construe it as a 60B because father is not objecting to anything done before the magistrate. Father in no way says the magistrate committed reversible error, granted legal custody, or he didn't have a right to participate, or he couldn't present evidence, no due process violation. There's no ground he asserted in his objection. And the judge makes very note that, I'm going to just construe it as a 60B because he's not saying the magistrate committed any error whatsoever. So, but
the courts have a history, though, don't they, of, people will file, some attorneys, pro se especially, but even attorneys will file things that's not exactly mean the right thing. And the court have lots of case law that talks about court construing motions in different manners in order to achieve justice. So.
Correct, Your Honor, that does happen.
And with the 60B, you have to have a final appealable order to begin with.
Correct. And this was a final appealable order.
I thought you said it was objections. Maybe I misunderstood.
He filed objections
To the magistrate's order.
to the magistrate's decision.
Well, decision.
Correct. But when the judge ruled on it, the judge didn't reverse the decision. So she upheld her prior ruling, and this court has already held when the judge issues the initial ruling, that is a final order. So we're arguing there was a final order. And again, Your Honor,
So when they sign off on the magistrate, like all the courts do that.
that is a final order according to this court. Now, I would note on page 7, Your Honor, I cite a block quote from Culligan versus Miller, and it says right here, this court has repeatedly recognized that the failure to identify which portion of a 60B is being invoked is fatal to the 60B motion because the second prong of the GT test is not satisfied. Neither the responding party nor the court can be expected to divine the specific grounds upon which the movement is seeking relief. Well, that's here. And in fact, again, when the attorney for the father says, we want custody, in their mind, they were not even asking for a 60B. Basically, they just want another bite of the apple. And again,
Well, they may not have thought it was a final appealable order.
they may not have. And that's,
Because, if it's not a final appealable order, you can always ask for reconsideration.
That's
File
correct.
Objections, there's all kind of remedies you can handle.
correct. I would agree with all that if they would have chosen any of those routes.
Counsel, isn't there case law that basically says the better course, when possible, is to get to the merits of something?
Sure, but not at all costs. Absolutely.
At what costs were there here? I guess you were involved as the GAL here, so I'm wondering in terms of your representation of the child or children.
Well, I have standing, first of all, to be.
I'm not saying you have
Okay.
standing. If you didn't have standing, you wouldn't be here. We would have taken
Correct.
this a long time ago.
But my fear is the child would go back to father. And as the child's guardian, that would, in my opinion, certainly not be in the child's best interest.
But you're the GAL, you're not the child's personal attorney.
I am the child's attorney guardian.
Attorney guardian line.
Yes, I am, sorry.
All right, sorry on that.
So I am both
Okay.
in this case. So if there's no further questions, I'd ask the court to reverse the
And
trial.
CSB has not filed anything, so they're not objecting to this at all.
No, but they did, after the father filed his objection, CSB did file a response saying, we disagree, this is not even a 60B motion, the court shouldn't grant it. So, all right.
All right, then